Maybe your lordship's time leave to mention a matter. I mentioned upon notice, this is a recalling application of your lordship's order by which the appeal was wrongly withdrawn. Your lordship said that your lordship will constitute a breach. This is the last order passed on 23rd of July. The urgency is that your lordship is suffering an order of eviction. They have taken possession and my tenant has already preferred an appeal. That is moved before court rule 16. So lordship can accept this matter, your lordship.
Alright, we'll see.
Then the bench is constituted.
To the chamber.
Bench of Justice Prashad and Justice Supreme.
We'll see.
Grateful. Grateful.
May I be permitted to mention a matter for inclusion under the heading
Give the inclusion slip. Inclusion. Inclusion.
The one which the Learned Council mentioned right now.
That recall matter.
Yes, ma'am.
Yes, give it.
Grateful, ma'am.
Supriyo.
Item number 1. Well, item number 1 is appearing for the first time before the lordships. This is a assigned matter. On the last occasion, his lordships, the Honorable Acting Chief Justice, released the matter on his personal grounds. He himself has appeared for the petitioner back in 2013. But I crave leave to file this supplementary affidavit.
WPCT.
WPCT.
Supplementary affidavit.
Supplementary affidavit annexing the trial court's order. There is a criminal case and a disciplinary proceeding. I have been acquitted in the criminal case.
That is a development during pendency of the
pendency. Yes, that has been. I've been acquitted in the year 2025.
Your Lordship, I'm appearing for the Union of India. An appeal has been preferred against that acquisition, Your Lordship. This is
doesn't matter. There is no stay to
right.
There's no
just a question of having it on record. So you have given a copy.
Your Lordship.
My lord,
Serve a copy.
I'm serving a copy. May that be recorded.
The
Item number 2.
My lord, I am for the appellant. My lord, this appeal is not maintainable before this honorable court. So the valuation is only 1,50,000.
so we leave.
Yes, lordship, we will take back. But the problem here is, lordship, we filed this appeal against the final decree in a partition suit. But the certified copy which has been annexed is the preliminary decree. The judgment and decree of the preliminary decree. Lordship, this is the final decree.
If you want to withdraw, then what is the point in facing it?
No, but lordship, the correct certified copy should be written with the record. Lordship, this is my original.
That's the final decree.
This is the original. Your lordship's list, I will instruct my class to just teach the actual lordship.
You are not given the certified copy. The certified copy of
Lordship, my clerk will be providing the
Yes, do it.
photocopy and will take back the original. Along with the preliminary, along with the Lordship, that defective certified copy of the preliminary.
You want to take it back, to use it before the
No, we don't.
appropriate.
Okay. We only want to challenge the final decree, but we have annexed.
Yes, you take it.
Now.
This item number 3.
Lord, this is my appeal, my lord. Yes, assigned before your lordship, my lord. Coming up.
AC on नहीं है. Each one.
Can you fix a date, my lord, subject to your lordship's convenience, sir?
You don't want to do it today.
Lordship, it's an assigned matter and it came up for the first time yesterday. We only
So
came
that
to
is
know
for
that.
us, that is difficulty for us, not for you. You don't want to do it.
Your Lord- in next week, anytime. Subject to your lordship's consent. Instead of 17th, if your lordship, I may not be in town, can it be 18th, your lordship?
18th. 30th level.
Item number 4. IFS for the petitioner, my lord. This matter also relates to resignation of a doctor. Or I was favored with an order of the tribunal.
Short for instructions, they've asked for some time, lordship. Next week, lordship, things will.
The matters on.
Item number 5.
My lord, I am for the petition.
When did you file the OA? 24. What is the issue?
My lord, the issue is retrospective effect of a.
My lord, the petitioner joined the public health directorate as a sub-assistant on.
Please use your mic, yes.
My lord. My lord, the petitioner joined the Public Health Engineering Directorate as a sub-assistant engineer on 21/7/1980. Then he cleared the Public Service Commission on 1991. And then under the 1988 recruitment rules, promotion from sub-assistant engineer to assistant engineer required a minimum 10 years continued services, confirmation as sub-assistant engineer and passing prescribed PSC examination. Then the petitioner fulfilled all the eligible criteria. Despite fulfilling the eligible criteria, the petitioner was not promoted at the appropriate time. He was promoted in the year of 2007. Whether he passed the examination on 1991. Persons who are junior in the petitioner in the gradation list were granted retrospective promotion to the post of assistant engineer.
What happened before the tribunal? Is it, has it been adjudicated before the tribunal or?
My lord, it is
Where is
adjudicated,
the
but
order? What is the
continuous delay is happening, my lord.
What is
And
the date of the order? Tribunal's order, please give us the date of tribunal's order.
my lord, P2 151.
151.
Volume 2. Oh.
My lord, pardon, P2 163. P2 163, my lord. Annexure P2 163 page.
So it is not adjudicated, it's still pending.
Still
We asked you whether it is pending or adjudicated, so it's pending. So under which rule the benefit is to be obtained, and you want it from 2007
1995, my lord.
and you have come to the tribunal in 2024.
My lord,
On behalf of the state in this matter.
Yes.
my lord, there was a notification in 2020 where we got to know that from 1998 recruitment rules, promotion from sub-assistant in India to assistant engineer required a minimum 10 years experience and clear to be PSC to be cleared.
And till that day, you were not knowing what is required to become go to the higher post. Why? The issue of delay is there. It is a limitation in the Administrative Tribunals Act.
There are several Supreme Court judgments, my lord. The delay is not a factor in retrospective promotion.
Give us one that this statutory bar of limitation can be overcome just because you say so. How do you explain this? How many years of delay? 20 years. You are claiming from 95 and you are filing a
2016. 2016, he retired from the service. In the year 2018, the executive engineer issued a communication where he saw that some of the junior employees to him, while he was in service, got a retrospective effect. Now that becomes the subject matter of an original application, which is colloquially known as OA before the SAT, that is State Administrative Tribunal. And that is pending before the tribunal. If your lordship kindly takes the grounds for which this application has been moved, paragraph 8 of the brief of your lordship.
Yes, what is it?
He says that it is pending over there, members are not there. So on the self-same relief, he has filed this.
So what is wrong with that?
I leave it to your lordship.
There is a judgment of the Supreme Court. What is wrong with that?
That he wants to show on the ground of delay.
No, that is not the point. The point is he has approached the tribunal in 24. Whether he could have approached the tribunal in 24, if that statutory bar operates, it will not be overcome just because we are going to assume the jurisdiction in the matter.
But I didn't want to go into the merits of the matter.
Same thing is all right. It's not a question of recurring. See, promotion, party rights accrue. Issues of seniority arise. Same thing will not apply here. Same thing is for a continuing wrong because there is some recurring loss or some recurring violation of your right every month because of some salary or something like that. You are asking for a promotion. How you can get a promotion with 20-25 years retrospective effect? And how does it? Tarsem Singh does not speak of limitation.
My lord,
Under the Administrative Tribunals Act, there is a limitation. Come to section 20 and 21. Tarsem Singh is talking about delay and latches. Yes,
my lord, kindly give me some time. I will find some order, my lord.
as prayed by the look at section 20 and 21 of the Administrative Tribunals Act. It requires exhausting alternative remedies. There is a statutory period specified. You have to invoke the jurisdiction with so many days. You're not done it, then we cannot overlook it in a big just because we are exercising jurisdiction instead of the tribunal. It says any date. Next.
17th August.
Item number 6.
My lord, this is also a similar matter
of the state. Here there is a limitation. Here that
Similar matter, my lord.
Same. Same on. Same.
Item number 7.
I am for petitioner minus short personal.
I am for the railway, my lord.
Short personal.
One minute.
Open the brief, madam. Let him come. What is the big problem?
Odisha for demanding and accepting illegal gratification of rupees 1.5 lakh from Sri Ajay Kumar Kishan Dev Chechi, the manager of RR Roadways Private Limited, for his personal gain, for removing of two numbers of private vehicles carrying ODC, which was detained at National Highway number 5, bearing number CG number SSR 2 CG number SSR 35 kilometers away from Balasore station by passing through a Bampada LC gate. During the course of raid, rupees 136020 was found in his personal wallet, and they further conducted raid in the railway residence of Sri K. Pathak IPF RPF at Balasore, from where cash rupees such and other documents were seized. This is the main charge. Then even he is central government holding the supervision post had given illegal order to 4 on-duty staff like as Sri D.R. Rao, Head Constable, G.S. Sethi Constable, P.K. Panda Constable, and Sri M.B. Mehra Constable to apprehend 2 private lorry daily drivers from local area without informing police, as well as having no case reference relating to RPF. Then 3, both the drivers were illegally detained and RPF post BLS from Bilaspur from 30 hours of 22/11/2000 to 48.40 hours on 23/11/2013 without making any detrimental personal search of entry in hazard register. Unlawful detention, their vehicle documents was also kept under custody. Now, my lord, my first ground is this. From the first charge, my lord, it is stated that SP raid, I was arrested and some money was recovered from my quarter. But neither the person who arrested me, the officer who arrested me, neither my lord called for in the inquiry. The driver who was detained was called for inquiry. I specifically stated that with a view to prove the charge, you please ask them to attend the inquiry. None was, my lord, called for in the inquiry proceeding. My lord, your lordship kindly come to written defense statement, my lord, is your lordship kindly state a page 95 of my paper book.
Ninety-five.
95 of my paper book. In this instant proceedings, total 15 PWs were examined. Those are the officer and staff of RPF, and 27 documents were exhibited. In order to, lordship kindly mark it, I have specifically stated, in order to encourage the evidence of a public witness and to enable
All right, so when,
finalization.
yes,
of the
we have
inquiry.
understood, you are saying the complainant was not examined. And the arresting officer was not examined.
Complainant as well as the officer who arrested me, who recovered amount, none of the officers were called for. In the inquiry
See,
proceeding.
the allegation is that you have taken 1,50,000 rupees bribe. There is no recovery of 1,50,000 rupees bribe. There is recovery of some money from your wallet. That is not the, perhaps not the illegal gratification. But regarding the complainant not being examined, you have stated, so where is the inquiry report?
The charge is that driver was detained at RPF post illegally. None of the driver was called for to prove the charge against me.
Where is the inquiry report?
Yes, yes. It is the important.
Yes, let us see the inquiry.
Let's see, my lord, what the inquiry officer has done in this case. The inquiry officer only Well, what happened in the
Please give us, let us go. Yes, what else? What other point?
well, 115 started review of findings. 115. Have you also got it?
Yes.
You will also kindly see what the inquiry officer has done. The inquiry officer only quoted the statement of prosecution witnesses in respect of charge number 1. Thereafter, in respect of charge number 2, we quoted the evidence of the prosecution witness number 2, prosecution witnesses. Charge number 3, he quoted the evidence. But there is no independent assessment. He did not apply his mind. Lots of Kalishi, and he stated that the charge were true. Lots of Kalishi, there is no independent assessment of the inquiry proceeding. How the inquiry officer apply his mind? How the charge is proved? Under what basis? The statement which was recorded against the charge, it is also in my favor. Nothing was there. That is why, my lord, it is non-application in mine. Well, the judgment of Apex Court is in my favor. No evaluation of evidence. Nothing is there. Independent assessment is not there. It is a perverse finding. It suffered from non-application of mine. Judgment advances are. My lord, while granting stay order, my lord, the coordinate bench, my lord Justice Dipankar Doctor, Lordship Kali, his lordship came to the conclusion Hello, Anil Kumar.
Let us see, you were given an opportunity of second show cause.
Second show cause notice.
Where is your reply to the second show cause?
After Kali, come to page 141. Lordship, I am reading your Lordship Kali, come to 142.
September.
আরে থামেন না এটা ফার্স্ট শোকজ দুবার আমাকে শোকজ করেছে
Address us.
Yes,
Don't address him, address us.
sorry.
Yes.
Your Lordship, kindly reply to the second show cause notice, Lordship, kindly.
What is the date of the second? Yes, it's at 141. Second show cause is of 7/7/2014
Lordship, kindly 7/7/2014.
is the second show cause.
Second show cause.
Where is it? Which
No,
page?
my lord.
Please wait for your turn. Yes, which page? Second show cause.
Lordship, kindly see, you are hereby advised to submit your reply within
Sir,
5 days. Sir.
where is which?
So this is a second show cause,
Which page, sir?
126. You are hereby so called. Why a punishment under rules such and such will not be taken against you for the lapses at the inquiry officer submitted his findings in the above charge sheet holding you guilty. Copy of the findings is sent herewith.
This
You are
is
hereby
the show
advised to
cause- this show cause in respect of the proposed punishment.
so called previous punishment. So I will give a reply. Let's say kindly come to my reply. Start from 141. Let's say kindly come to 142. Paragraph 3. On going through the inquiry report, it reveals that the inquiry officer has examined 15 PWs and exhibited 28 documents. Wherein the inquiry officer cited the deposition of the PWs like 5 PWs, such and such, such and such, such and such, to establish charge number 2, 8, 2, PW 8, such and such, to establish charge number 3, and none was examined or no PW deposed to prove charge number 4. Then, on going through the reason of findings of page number 15 to 25, the inquiry has mentioned the deposition of PWs in gist and the question and answer of the charged officer and PWs. No discussion evidence, kindly mark it. No discussion of evidence of PWs was made in the inquiry report. I have stated. Then you will also kindly paragraph 4. I have submitted my detailed defense statement in 18 pages before conclusion of the inquiry in time on such and such date. There was no any discussion elaborately made. When I filed my detailed defense statement in the inquiry proceeding, not a single line was discussed. No ground was discussed. Your Lordship, kindly see for a moment. All stated. Conclusion, my lord, page 125. I have gone through the defense statement and found all that. What the ground I have taken in the defense statement, nothing was discussed. No ground was disclosed as to why my written defense statement was not considered. How the ground in my written defense statement was overridden by the evidence of the prosecution witness. Nothing was discussed. That is why, paragraph 4, page 142, I have stated, I have submitted my written defense statement in 18 pages before conclusion of the inquiry in time on 18 May 2014. There was no any discussion elaborately made on my written defense statement. Nothing was highlighted or pinpointed by the inquiry officer on my defense statement or defense document. Then, next page. It is well stated in law that after obtaining defense statement from the charged officer, the inquiry authority will consider all the evidences on record and record its finding on each charge clearly, precisely and unambiguously. The findings should not be concluded in vague phraseology. The consideration of the evidence by inquiring authority should be unbiased and with an open mind. The inquiry officer should consider of the evidence on record fairly and objectively and should not go out of his way. In this regard, RPF Rule 153.16 clearly indicates that the evidence submitted by the charged official in his defense, the inquiry officer shall proceed to record the evidence during the course of submitting findings. In this case, the said Rule 153.16 of RPF Rule 1987 has been violated and a big blow to the laws of principle of natural justice. Then, it may mention here that the findings and conclusion of the inquiry officer should be based on evidence, wherefrom it can logically or reasonably follow. The materials and records should support the findings. The viewer should not exclude the material which the relevant also. He should not base his findings on conjecture and surmise and suspicion. Otherwise, the conclusion could be perverse and it cannot be sustained. The inquiry report and findings of an attempt to lay the truth based on the basis of evidence were used before the inquiry officer. The report of the inquiry shall not be cryptic, evasive, and confused document. It reflects upon the sincerity and the seriousness of the person appearing the same towards the assignment given to him. The acts may cause irreparable damage to the rights of the individual. That's why I am submitting my defense document, such a copy of original complaint made by complainant Sri Ajay Kumar Chachi, addressed to SPB Balasore on such and such, wherein the date, time and place of occurrence has been mentioned. Further, I submit copies of exhibits 20 and 20A as recorded evidence as my defense document. The inquiry officer did not take point 10 in both the recorded evidence to discuss carefully considered as recorded evidence in my support, which evidence was not taken into consideration by the EU, which is against the principle of natural justice. Then, my lord, the next count 7. Sir, none of the PW has deposed during inquiry that both the divers were detained at RPF post Balasore. No such evidence, either documentary or oral, was adduced during inquiry by any of the witnesses. Nothing is mentioned in the complaint of the complainant about illegal detention of both the alleged driver of RPA Bilaspur addressed to SPCBI Bilaspur. There is an abundant contradiction in this deposition of PW7 and PW10 in regard to keeping and taken out of both the drivers in Hajar. It was difficult to see how the prosecution witness were justified in contending the findings recorded by the EU, bound the charge officer is illegal, is illogical, anomalous, and erroneous. Then, that's why I have been charged number 3 in that failed to observe and maintain the direction of DGRPF Railway Board in regard to interrogation of detention, which is also reflected in the statement allegation as same without elaboration. In spite of that, Honorable Supreme Court held that since the direction was not a rule made under Article 309 of the Indian Constitution, it was no statutory force. It merely contained instructions set out by the competent authority about the procedure to be followed. Course Rajkumar Bhas Union of India. Then 9. That's how it has been reflected in the inquiry report that none of the PWs concerned made any diary entry, endorsement, or comment certificate or any recordical evidence could be adduced by the inquiry officer is available. Example PW1, PW2, PW7, and PW8 clearly stated that alleged driver were not put in Hajar, and no any PWs corroborated in their deposition regarding detention of alleged driver. Then it is very important, my lord, paragraph 10. That's why I felt in this particular case, there has been no proper inquiry because some serious defect has crept into the inquiry and some important witnesses, the complainant, both the alleged driver on duty, gateman of the exchange gate in the time of occurrence, were not called for, were not called for or available and was not summoned or not examined for some other reason, which examination of themselves may support in my favor. An actual fact would have been came into picture. Then you will kindly come to paragraph 15. The following facts which have not been adduced by you during preparation of finding. On the basis of contradictory statement, PW1, 7, 8, and 9, I have been guilty. But they are accepted that the order of detain erosion was illegal. And as per rule, the legal order should not be obeyed by the subordinate. It is also mentioned that the ignorance not aware about the law of duty is not called injustice. They also stated that they not produced the arrest driver before me and never noticed by me and want to talk or meet with them. Hence, it is clear that the above mentioned 4 PW were acting illegal work for self-gain. No any PW stated that I obstruct them for illegal action like entry in Rosenamcha comment certificate, etc. The above facts clearly accepted by PW7 during answer to question number 16 and 9. In reply of question number 19 duly asked by charge officer, as I was not hindered to take follow-up action. Then you will also kindly see officer stated in finding that the KM Pathak PW10 proved the charge, but in answer to question number 8 asked by charge officer, he clearly disproved the charge. Then in reply to question number 14 by Sri S.N. Mukherjee, who was conducted preliminary inquiry, has stated that he did not collect any evidence regarding illegal detention, arrest of alleged driver. My lord, I have submitted. Then you will also kindly see the disciplinary authority, my lord, ordinary disciplinary authority, my lord, after going through the findings, recommended for deterrent punishment and send the case to the higher authority. Let's kindly come to the findings of the higher authority, very important. Findings of the higher authority. And it is page 163. This is the Inspector General RTF, who is the actual disciplinary authority, impose punishment, major punishment, authorized to impose major punishment. What is the finding? That's can come. On scrutiny of the case file, the following points have come to light. The list of witnesses by whom the article of charge against Sri Kalika Pathak, Inspector R.K. Blasfoot, were proposed to be sustained has been enclosed as Annexure 4. In this annexure, name of the party charged Kalika Pathak has been mentioned as a prosecution witness, serial number 50. Then, the name of Sri K.P. Pathak, Barifata has been mentioned up to present, not necessary. 3, very important, 3. Neither Sri Ajay Kumar Chetty, manager, RR Roadways Private Limited, the complainant in the CBI case, nor the 2 drivers, namely Ram Bilas Chaudhary and A.K. Mohammed Saeed, who were allegedly detained along with their vehicles and confined by RPF for illegal money, were made prosecution witness. The IO also did not call them. Dr. Kalimakri. It is the observation of the disciplinary authority. The IO also did not call them as IO's witness during the DR proceeding for examination and cross-examination by the party charge. This person would have been very crucial in deciding the culpability of the party charge and in bringing out the truth in the DR proceeding. Then you will also can come. Ajay Kumar Chetty, manager, RR Roadways Private Roadways, with CBI Bhubaneswar on Atu against Inspector Bilasful for demanding bribe. In this affair, he has mentioned that his 2 vehicles were detained on such and such date along with their drivers. When he connected conflicted Pathak, Inspector Bilasful, on such and such date, he demanded rupees 1.50 lakhs for releasing the above mentioned vehicle. However, in the charge sheet, the date of detention of vehicles drivers have been shown on such and such date. It has not been clarified during the inquiry. Then,
one has been that was added something. Sorry. Then the this whatever this is name shape
Criminal trial also took place.
Huh?
Were you implicated in a criminal case also?
No. Nothing.
Then why it is talking of CBI?
They stated CBI, but no criminal case was initiated against me. Even that CBI officer, it was alleged that he arrested me. It was alleged that he recovered such an amount.
There is no CBI case.
No CBI case. Now your lordship kindly come to 164, paragraph 5.
Yes.
No, AC, Assistant Secretary 5. TL number 5. Assistant Secretary Commissioner RPF OL KGP recorded the statement of Sri Ramvilas Chaudhary, one of the divers on 23rd 11/2013 itself, which has been mentioned in the preliminary report of S.N. Banerjee, Assistant Secretary Commissioner Workshop Kharagpur, submitted to Senior DSC, Divisional Secretary Commissioner Kharagpur. During the identification parade conducted under the supervision of SP CBI BDS on such and such date, another diver by name A.K. Mohammad Saeed was also present, but his statement was not recorded. The statement of Sri Ramvilas Chaudhary was taken as relied upon document and it was exhibited during their inquiry. But even after the objection, Lordship kindly mark it, even after the objection raised by the party charge, he was not called for proceeding. Then your Lordship kindly come to 6. No CBI official, Lordship kindly come to 6, very important. No CBI official was made PWs in the DAR inquiry to corroborate Kraft's story involving Sri K. Pathak.
No, anywhere the case number has been mentioned. Has the CBI case number been mentioned anywhere?
Yes. First charge.
CBI case number, special case number, has it been mentioned anywhere?
Case number to mention.
Yes, yes.
Special case number, whether it has been mentioned anywhere?
Yes.
Where is it? CBI case, special case number?
That is why the observation of the Inspector
There
General.
must be some RC case number. You just told us that there is no CBI case. Therefore, we are trying to ascertain whether anywhere in the document any RC case number has been mentioned.
My lord, let me go through the.
Yes, there is a CBI case. There is a CBI case. Is RT 21A of 2013. RT 21A of 2013 under section 7 PCA. Here it is written 4. And here I just saw some.
List of reliable document.
It is problem A. Yes, there is a CBI case. CBI case number is RC 21A of 2013. It was lodged under Section 7 of the Prevention of Corruption Act. What happened in the CBI case?
It has not yet been, my lord,
Still pending.
pending.
So your point is that firstly, the complainant has not been examined. Secondly, the 4 persons who were allegedly detained the drivers, they have deposed, but the true drivers were never produced.
And the official who arrested me and recovered,
That will come later. So this is part, even if they are not examined and this is fulfilled, then that will be sufficient. Your being arrested is not a charge. The charge is that you have asked these 4 persons to detain the truck because it has moved the overhead wire and crossed some gate. They have gone and they have apprehended the truck without any case being lodged. They have brought them to the RPF post. They have handed over, and in the process for releasing them, you have taken illegal gratification. This is the charge. So there is no complainant. The true drivers are not there. The corpus which was said to be the illegal gratification, that has not been produced. And lastly, you said the inquiry officer's report shows total no application of mine. That's all. Yes.
my lord, only one thing, my lord.
Yes.
While passing the stay order, the coordinator meant to
That
also
is a
observe.
tentative. That is tentative. Will not be carried by that.
No, no.
Today we are finally considering the matter. Yes.
My lord, I have got some judgments.
We'll see it. We'll see. All right, you show us the judgment. First, let him show the judgments.
Purpose I am citing the findings of the inquiry officer purpose and non-application of mine. AIR 1985 Supreme Court, page 1121. Let's kindly come to paragraph 5 and 6. Paragraph 5. Thereafter 6.
1121.
Coordinate bench while passing stay order also rely upon this judgment. We have extracted paragraph 5. We have extracted the charge framed against the appellant. We have also pointed out in clear terms the report of the inquiry officer. It is well settled that the disciplinary inquiry has to be quasi-judicial inquiry, held according to the principle of natural justice. And the inquiry officer has a duty to act judicially. The inquiry officer did not apply his mind to the evidence, except setting out the names of the witnesses. He did not discuss the evidence. He merely recorded his ipsy that the charge are true. He did not assign any single reason why the evidence produced by the appellant did not appeal to him, what has considered or not credit worthy. He did not permit a peep into his mind as to why the evidence produced by the management appealed to him in preference to the evidence produced by the appellant. An inquiry report is a quasi-judicial inquiry, must show the reason for the conclusion. It cannot be an ipsy of the inquiry officer. It has to be a speaking order in the sense that the conclusion supported by him. This is too well settled to be supported by a precedent in Madhya Pradesh Industries Limited versus Union of India, Sajansa. This court observed that the speaking order will at best be reasonable and at its worst be at least a plausible one. The public should not be deprived of this only safeguard. Similarly, in Mahavir Prasad versus State of Sajansa, this court reiterated the satisfactory decision of a disputed claim may be reached only if it be supported by the most cogent reason that appeal to the authority. It should all be so where the quasi-judicial inquiry may result in deprivation of livelihood or attach a stigma to the character In this case, the inquiry report is an order sheet which merely produces the stage through which the inquiry passed. It clearly discloses the total non-application of mine. And it is this report on which the general manager acted in terminating the service of the applicant. This could not have been a gross case of non-application of mine, and it is such an inquiry which has found favor with the labor court. Where a next paragraph, where a disciplinary inquiry officer, the livelihood and is likely to cast a stigma, and it has to be held in accordance with the principle of natural justice. The expectation is that the report must be reasonable. The court then may not enter into the adequacy or sufficiency of evidence, but where the evidence is annexed to an order sheet, and no examination is established between the two showing application of mine, we are constrained to observe that it is not an inquiry report at all. Therefore, there is no inquiry in this case. What the name and the order of the termination based on succession, disclosing non-application of mine.
Yes.
And another decision, my lord, I am placing before your lordship that, my lord, the complainant and the divert was the most important witness. Their evidence was most important. My lord, lordship, can you see the judgment of Apex Court, 1999, 5 SAR, page 151. Lordship, kindly come to paragraph 3. Paragraph 3. Before us, the sole ground urged is as to the non-observation of the principle of natural justice in not examining the complainant, Sri Virendra Singh, as witnesses Jagadish Rao. The tribunal as well as the High Court have just aside the grievances made by the appellant that the non-examination of those two persons had prejudiced the case. Examination of those two witnesses would have revealed as to whether the complaint made by Virendra Singh was correct or not, and to establish that he was the best person to speak it to its veracity. So also Jagadish Ram, who had accompanied the appellant to the hospital.
Fact that even the money. No for any. Produce. This. That is 13. That's good. Recovery is 2.47. Whether or not he was even brought in anywhere. Yes.
Examination of these two witnesses would have revealed as to whether the complaint made by Virendra Singh was correct or not, and to establish that he was the best person to speak to its veracity. So also Jagadish Ram, who had accompanied the appellant to the hospital for medical examination, would have been an important witness to prove the state or the condition of the appellant. We do not think that tribunal and the High Court were justified in thinking that non-examination of these two persons would not be material. In these circumstances, we are of the view that the High Court and the tribunal are in not attaching importance to this contention of the appellant. Paragraph. Here.
Anything else?
I'll take you first. So there is no place first. Ground the revision was dismissed. I will not take you to the but rather I must tell you the second so-called notice has been filed. He did not choose to reply the second so-called notice. The reply was read by valid which was when first so-called notice. Thereafter some irregularity was found by the authorities. But because second so-called notice on 21st September So no reply, final retribution.
That was the impugned order.
Yes, that was dismissed because unless there is violation of mutual justice, nobody can challenge the so-called notice as per the Supreme Court judgment. So that is the ground on which the retribution was dismissed. So before I take you to the
Where is the 21/9/2017 notice?
note, kindly come to note page 170, page 170. September 17, page 170.
Yes.
Now, my lord, I prepared this short list of the 3 pages because the order impugned. The order impugned is 21 pages. It will take some time. Order impugned is 21 pages. I prepared a short list of date note. You should not apply the note the entire facts note how the appellant has abused the process of the court for 10 years. He was red-handed. He was not caught red-handed while taking bribe in 2013. Now we are in 2026. Kindly see, my lord. There are 3 occasions he was invited to give justification. 3 occasions, but he could not justify. So kindly, my lord. So 3rd November 2013, criminal complaint made by complainant Mr. So-and-so. 20th November, according to the FIR lodged by Sri Ajay Krishna, on this day, 2 drivers along with the vehicles were detained. 22nd November, according to the charge sheet signed issued by railway authorities, 2 drivers along with their vehicles were detained on this day by petitioners. On 23rd November, FIR lodged by Mr. Kishan with CBI, Bhubaneswar against the petitioners for demanding bribe. 10th November 14, charge sheet, query number so-and-so, was framed, issued by Senior Division Security Commissioner, PF, against the petitioner when departmental proceeding was initiated against him. 4 charges were framed. No, the 4 charges were framed against him. That is not there in the charge sheet. 4 charges. Kindly 8th May 2014, petitioner submitted his final reply statement wherein irregularity, illegality appearing in the disciplinary proceeding was taken by him. In the first reply, he said no irregularity. Then on 5th of June 2014, the inquiry report was filed. My identifier has placed only the some pages. There are 10 pages recording the evidence of all the witnesses. Then there was after 6 pages, he is given his own finding that yes, he is guilty of the charges. The ground which might have been taken in while the admitting appeal, that the no application of mind by the inquiry officer. He has applied his mind. He has given finding by in 6 pages and he has found him guilty. Then on 5th June 2014, he has given the inquiry report has been given. Then on 7th July, again the first so cause notice given. 2nd July, the first so cause notice given. When he has given reply, he could not justify that he is not guilty. Then again, or matter was referred to the senior officer. He found some irregularity and he remanded back to the matter to the inquiry officer for reconsideration and for some clarification. Then it was clarified, Lord, on 18th April 15. A order was passed. A speaking order was passed that there was a serious guilt found by the charge file found by against the appellant. Then Lord, on 10th of May 16, then Lord, this was the letter for again later given that there is a speaking order that there irregularity was found. This is the letter given by the department, the 10th of May later, some irregularity. Then can it is 17 December 16. This is not the letter of my learned friend's letter that there are it was clarified, found serious severe punishment should be required. Then second so-called notice on 22nd September 17. Issued by the IG comes Chief Security Commissioner to the petitioner, where he was held guilty and asked him to submit his representation against proposed punishment. This was not replied by him on 22nd September 17 later, and it was filed. Now, Lord, after this, Lord, the writ court has, Lord, tried to dismiss the matter. But initially, then appeal was preferred. Then appeal court matter remanded back to the writ court again. The writ court again heard the matter. Again, writ court had dismissed the matter on the ground that there is no perversity, there is no violation of natural justice, and there is no reply to the so-called notice. On that ground, it was dismissed. Now, in the appeal, my lord, the coordinate bench, while hearing the matter, my lord, was a bit annoyed because during pendency of the appeal, he was dismissed from the service. The honorable court held that what was the hurry? Why he was dismissed? You should have waited up till appeal was disposed of. His lordship has stayed the order. For timing has directed the department to pay the subsistence allowance to him and treat him as a suspension. He is taking advantage of that order from 2019 until today. He is getting the allowance, no work, nothing. He is getting allowance. Now, Lord, that is the crux of the matter. There is he is a RPF officer. He is part of the force. Some credibility is required. He was found guilty once, second, thrice. There are thorough investigation. There is no ground to evade him from the service. Now, Lord, kindly allow me to place the order impugned, so that Lordship, the thorough case has been placed by the single judge.
Suppose you said there is a 6-page consideration. So was the consideration. Why you want to read that?
My lord, inquiry officer. Inquiry report.
Yes.
Yes. Please come to page 101. 10, start from 101, my lord.
Yes.
Statement of charge. Having Mr. Kalika Pathak is
No, you said there is a finding. Where is the finding? Don't read the statement of charge and deposition.
my lord. Lord, page 102, my lord, is the
No, all that is deposition.
no, not 1,
All that is
four
statement.
charges are there. Not page 102, bottom of 4 charges. Charge 1, he is a central government servant holding the supervisory post had been illegal order to 4 on duty staff like a RD Rao head constable, Sri so and so, to apprehend 2 private lorry drivers named so and Ram Vilas Chaudhary from local area without informing police, as well as no case reference to RPF. Charge number 2, both the drivers were
Sir, you are when you make a submission, please show us the material in support of your submission.
Very good. Now,
Not unnecessarily read a charge and the statement of the witnesses. You said there is a finding, a consideration. We are looking for that consideration. Show where is the
I will
consideration.
just show you that the finding and the recording of the deposition.
We don't want to see the deposition. We have already seen it. We want to see whether the inquiry officer applied his mind.
Yes, from page 104 to
Up to 114, it is only statement after statement.
these are the deposition.
Yes.
Up to 114, it is
Yes.
deposition of all the witnesses.
Yes.
Now 115,
Yes.
reasons and findings.
Yes.
On assessing the facts during a course of inquiry by examination of all listed PW exhibits, defense statements, finding is delivered on the basis of charges as funded below. PW1, Sri D.R. Rao, head constable, deposed that during so and so at so and so office, the Sri Khatak left for so and so, which touched one so and so, and subsequently they were touched on so and so, they were able to trace out the drug. Some say we are informed, able to trace out the drug. Say we are informed, able to over mobile phone and as per the advice, driver of this truck during question answer by so and so asked by party charged to PW1 about the verbal order given by inspector, whether legal or illegal. He replied that I can't say whether it is legal or illegal. Where as such act is illegal as applied to question 15 of the party charged by D. PW4 Sri so and so reports that he performed a shift duty on so and so date, but he did not notice any of the siders on 22nd November, but 23rd November at about so and so hour, a shift duty as PADW and he received verbal charge of.
This is re-recording of the statements. First, one recording of statement, then re-recording of statement. You said there is a consideration. According to you, where in this report is the officer's consideration? There is a recording of the statements twice. Now, after that, where is the consideration?
So the conclusion of page 1 to 5. Page,
Yes.
page 1 to 5, madam. Conclusion.
105.
1 to 5, 125.
Yes.
I have gone through the all evidence, statement of PW, defenses, statement, and found all the charges labeled against Sri Kalka Pathak Inspector RPF Balasur now at CNO are proved. Hence, I declare him guilty of the charge. This is finding.
Yes.
This is finding.
This is the finding. And complainant was not examined.
Complainant not.
Kechi.
Kechi
was not.
It was not. I don't think they have given.
He was not examined. The two drivers were not produced.
No, there are 17 witnesses were examined. 17 witnesses.
That we have seen.
We have examined. Complaint might not be, but there are 17 witnesses have been examined.
So according to you, even if they have not been examined, that is not detrimental.
But there are evidences. There are other evidences which can be proof that he has been not found guilty. And there have been constitution thrice. He was invited twice to justify. Ultimately, the last so-called notice, no reply, writ petition.
And how the punishment order, how it was brought on record by way of a supplementary affidavit?
By filing a CAN application, and no copy is annexed to the.
Which CAN application?
It is not part of the paper book. 10 number, my lord.
How the punishment order was brought on record? The punishment order was passed during pendency of the writ proceeding. You brought it in the record by in what way?
Before submission of the punishment order, I moved the stay was passed. Court has passed the stay order. Lordship, kindly see the stay order of the coordinate bench.
The stay order was passed after dismissal.
They stated that order of dismissal was passed, but court has considered that when the appeal is pending for consideration stay application.
That's a different thing. We are asking you facts only. Don't. The fact is after dismissal. So where is the CAN application?
My lord,
Where is the CAN application? Please show us.
আমি ফাইল করেছিলাম।
Where is the CAN? What order passed on the CAN? What is the order passed on the CAN?
ক্যান কি ফাইল করেছিলাম? ক্যান তো ফাইল করেছিলাম।
Not kindly
Please find it. We are coming.
kindly see minute page 270 of paper book. It is there. Can is not there, is not part of the paperwork, my lord. But can number is can was filed by management. One for state petition, double for 54,
My lord,
one for say of the
kindly come to the
549.
I move the writ petition before this honorable court against the second time show cause notice.
Yes, we are asking you where is the can?
But kindly go through the order of the coordinate bench.
We have seen it. We have gone through the order.
My lord, you can work file
Which
for
can?
immediate hearing. Logically, this is noted by the court. Kindly go through. Also,
Can there kota can kota?
Where is the can application challenging the punishment?
That's what this was by the coordinate.
Which can?
Why I filed the can for taking interim order and immediate hearing. Two can file. That's why it was mentioned in the
Can numbers, can numbers.
everything is mentioned. You logically see.
5495, my lord.
The unsuccessful, my lord, I am reading. The unsuccessful writ petition or indemnity number such as such is the appellant before us. Landed judge of this court by judgment and order dated at
Please seven of the order.
can number 4454 of 2019 is an application filed by the appellant seeking stay of protection under appeal. Can number 5495 of 2019 a further interlocutory application filed in the appeal by the appellant seeking to bring the record against that have offered to use the petition. The appropriate trial is made there for setting aside the order of the special trial condition. Whether 10 June was a week. If a respondent has not against the appellant, then circumstance is treated as on case. We have heard Mr. Mujumdar, learned advocate appearing for the appellant. So it was already learned advocate. We are inclined to call for immunity. We have to two interlocutory appeals, but having regard to the solution made by Mr. Das that the appeal may be disposed of this Saturday. We propose to discuss of the plan number and plan number such. He coordinates made by this common judgment and order. The appellant is an inspector of the railway production.
Yes, yes, we have seen. Yes.
My lord, lord, you got the can number, my lord. Can number is 54. 54.
5495. Yes.
Station, my lord, for setting aside the dismissal order. My lord, the coordinate bench had granted stay relying on Anil Kumar's matter in Supreme Court. Can you, my lord, see this order? In this case, the learned inquiry officer did not apply his mind at all. And on that ground, the inquiry report was. But
why we should look into that order? You have not challenged that order?
No.
Then?
No, that is the ground on which the court even has granted.
Sir, you are not challenging that order for so many years. What are you trying to say? The order is bad.
I am saying, Lord, the coordinate bench had
Yes.
stayed the order.
Yes. Which has remained challenged till date, unchallenged. No challenge from you. You can make submission on that order.
I am talking about interim order, my lord. Interim order of the coordinate bench.
Huh?
I am talking about the interim order granted by.
We are also talking about that order. You never challenge that order. That why stay has been granted.
I have applied for vacating interim order.
You keep applying.
My lord,
After hearing both parties, if a stay is passed, then it has to be vacated.
I have applied for this vacating interim order.
Very well. You
That
keep
is
it.
there, my lord. I have given a challenge by
Yes, you keep it.
My lord, in the lord,
There is some reference to a rule which said that the chief commissioner cannot be imposed by yes, chief security officer. So it was referred to that.
Yeah. Yeah.
Action. Prescribed issues. Submitted. IG was the opinion. No further consideration. It's the very popular. Ensure submit your presentation this year September. Was it by there the final no.
Yes. Any judgments you are relying?
No judgment, my lord.
Yes.
In substance, my lord, the finding of guilt is based on evidence, my lord, and finding by inquiry officer. This court not has if not but a soft note, my lord, may I give it to you for your convenience.
Not required.
People
Not required. We don't require any short notes. We will consider. Yes, take down. Heard the learned advocates presenting the parties.
And if not, you are president or you will be getting full benefit on everything. All on duty. Will be on duty, madam. Yes.
और consequences.
কাজ করে
This was very
I am grateful to you.
Item number 8.
This was taken up on Friday where the question arose that how could FMAT become an FME? This was when it was not produced. His Lordship, Rule 13 of the appellate segments, Lordship.
10 and 15.
13 and 15.
Act
So just, I have only.
Which chapter?
Lordship, chapter is chapter 5. General rules of procedure. Except is provided in Rule 14 of the chapter. So, Lordship found it. Get not. Oh.
Presented for admission.
Admission.
So is it a matter pending at the stage of admission or it's a?
The memorandum of appeal was filed. Maybe they did not require a stay and amendments. But it can come up. And if it is otherwise in proper form, if the first appeal tender number is transformed into a first appeal, miscellaneous appeal number. Same for.
Which is the provision which deals with the matter becoming a matter for hearing? Here.
Internal proceeding.
Should we take up this proof to matter?
Lordship, I mean, this matter, as far as I understand, Lordship, that since it has been admitted, I mean, it's
Admitted?
Admitted. I mean, it's a first miscellaneous appeal, Lordship. There is no order of admission, is there? There is.
No, that's what we are finding. There is no order of admission.
Order. Because since there is no stay application, I don't think there's any can either.
Perhaps not. Yes, there is no can application.
No can be.
And this is filed by state or by the?
It's filed by the state, Lordship.
So, Was any notice issued to the writ petitioner?
That's what I do.
My application file on.
Let me start.
Will not consider. The item number 9.
I appear for the petition. I filed the writ petition.
Notice is served.
My lord, affidavit of service filed, my lord. This time also, my lord, the private respondent refused to accept.
There is a refusal. What is the date of the affidavit of service? Where is the affidavit of service?
The last occasion I filed it.
That's good.
এখানে আমাদের কপিটা affidavit service plus
After 8/5/26.
yes. এইটা
Yeah.
This is affirmed on my lord. 8 May. July 2026.
The river there should be one copy. It's not April prior to that. Check. Taking the copy. দেখে দিন যে ওটা আছে কিনা
Item number 49.
That's what we were also discussing. But I think we will have to start afresh.
Arguments have been recorded. My proposal to you is, let's adjourn it for a week. We don't know whether this constitution will remain, will revert. We don't know for the present, whether it is temporary, permanent, we have no idea. So we can keep it after a week or 2 weeks. Then that is not lost.
Very well.
Otherwise, we have to start afresh.
Yes, understood. Yes, we understood. I think
If that is all right with you, then
yes, absolutely.
yes. The matter you should, yes, yes.
Very curious times ahead.
I'm joining Mr. Shen to comment.
Thank you. Thank you.
The oath was in so much haste.
Yes, but we could not come. Suddenly, well, we find in the WhatsApp groups that
Saturday.
it was
For their benefit and we.
yes, exactly for all
We
the
all congratulated and we told the ACJ it was a commendable job that he got it done so soon.
right.
It could be organized at such a short meeting.
Very well, Manoj. I still hope that I address this picture. Thank you. Thank you.
Item number 9.
Because there are two civil matters here. Just earlier order found that important to understand. Just go.
Yes.
The appellant before your lordship is the
Did we find the affidavit of service?
on the
Yes. This is the second place of the website.
This is can 2.
my lord can too.
And 2 is for
For my lord, stay of the judgment under appeal.
Can 2.
Can two take হচ্ছে
can 2 is for stay.
my lord, the prayer is restraining the respondent bank authorities from making payment of family pension to the private respondent number 3. That case.
Come to your page 5.
My lord,
Which can you have served?
my lord.
Which can you have served? Page 5 of your affidavit.
Sorry, sir, it is can 1, my lord, sorry. I beg your pardon, my lord, I beg your pardon, my lord. Can 1.
Can 1 is for what? Let us.
This is, my lord, for restraining the bank authorities from making payment of family pension to the private respondent number 3 and directing the respondent bank authority to furnish the account of the total amount paid towards family pension to the and the first legally married wife. Why I am telling that first legally married wife, that my lord, in a 125 proceeding, judgment was passed, which was filed by me against my husband, who was the
clerk in the State Bank of India. My lord, 125 proceeding was allowed, directing maintenance to be paid to me. It was being paid. It was not challenged. My lord, then my lord, my husband took premature retirement and was getting the pension. Then, while getting pension, he died. Then, my lord, I applied to the bank authority for family pension to be granted in my favor. When bank said that the employee has nominated the private respondent as the nominee for family pension. Which is not permissible under the rules. Pension rules. They are pension rules. Bank's own pension rules. In the judgment, my lord, of the 125 proceeding, the husband admitted that he for the second time married the private respondent. Page 30 of the petition, can 1. This is the page 30 of the petition. And 31 also. At top, page 30. The judgment starts from page 28. At 30, decisions with reasons. May I place it to your lordship? There is no dispute about the fact that the petitioner is the legally married wife of the opposite party. Hence, point number 1 is decided in affirmative. Then in page 31, the last but third paragraph, in the last first, second, third, 3, 4, 5, last 5 lines, it has been recorded. Moreover, during examination in chief, the opposite party, that is my husband, admitted that he had married again and Meera Sapui is his second wife and that he has a son from the second wife.
Where is the provision in the regulation?
But on the last occasion, my lord, I produced that regulation, my lord. My lord, kindly sees the affidavit, the declaration which has been filed by the deceased employee, my lord.
Yes, there was some provision for filing
Yes.
detail of dependents.
Defendants. My lord, kindly sees that page 58, my lord, kindly sees. 58 of this. Annexure R1. R1 to my affidavit that I filed.
Para 11. Point number 11.
My lord has got it. Clause 11 kindly sees, my lord, particulars of the family members to whom the family pension is payable now or afterwards per declaration of such and such. Well, we are not a civil code. We are not supposed to know that who is the actual wife and who is not the actual wife. We had to depend on this declaration given by the deceased whom when he was alive, my lord. At that point of time, this husband was alive.
You are relying upon some order passed in a section 25.
Yes, 125.
Where is that order?
My lord, this is my lord at page 31 first. Page 31 of my writ petition. First, second, third, fourth paragraph, last 1, 2, 3, 4, 5 lines. Moreover, it starts with the words moreover at page 31. Moreover, during examination chief, the opposite party admitted that he had married again and Mira Shafi is his second wife.
Respondent was represented before the writ court.
No. In the 125 proceeding. Yes, but in the writ court private
No,
respondent
my lord, the private respondent did not appear.
did not appear.
You also had some offspring.
I have one offspring. I have a son.
What is age?
Age কত জানিস ছেলের? 30 years. About 30 years.
So the next one is please starting with sir.
আগের ভিডিও তো করেছিল না?
Married on Mira Shafi, second wife. We have explained that he has a second from. So he can. Can we exist? If we are
Bank says dependent to be specified very for the bank. But I was thinking that some was maybe 19 or 18. Something, but he's saying 30 years.
The son is also a party here.
My lord.
Your son is also a party in this proceeding.
No, my lord, he is not party here. He was not a party, here also he is not party. He is not, second wife admittedly is not a dependent, my lord. And the pension rule says that in the event of death of the member, after retirement, the trustees may sanction family pension to the dependent.
Correct.
So she is not the dependent, my lord, second wife during my lifetime.
Pending applications, if any, stand disposed.
Item number 10.
This is an appeal by the state.
Draft of this, you said it was.
Of 2016 filed by the state of West Bengal. Lordship, I've taken down the particulars. I'll have to contact the client. There is I have to contact the officers, Lordship, for all the papers because there is a application for condemnation of delay with the delay of 172 days. Yeah. I've asked some of the
My lord, I just came to learn that this matter is appearing before your lordships, my lord. Lord,
What do you want?
It's for the respondents.
I'm for the respondent original applicants.
What is the issue?
Lordship, I haven't seen the papers at all. It's appeared for the first time.
What's the issue?
Your issue, my lord, I also, my lord, not properly.
Very nice.
My lord, what has happened is a long back 2016, my lord. Matter relates to 50,000. Related to, my lord, grant of non-practicing allowance.
The amount's been deposited.
Yes, yes, my lord. On last occasion, state submitted at the cost of rupees.
Yes, somebody was submitting that. It has been
Earlier, learned advocate representing this state. And my lord, it is matters that relating to, my lord, the grant of non-practicing allowance to, my lord, the homeopathic medical officers, teachers, who are under the service of West Bengal Health Service, my lord. At par with the Ayurvedic service, my lord, possibly, my lord. They are getting the
under the ROPA.
Under the ROPA, my lord. They are the getting, my lord, non-practicing allowance.
They are not getting, they are giving.
No, I'm saying Ayurvedic. Ayurvedic.
They are giving, not getting.
No, I'm not saying they are giving. I'm submitting, my lord, that the teachers under the Ayurvedic medical service.
So you are claiming parity with the medical medical officers.
My lord. If the matter relates to this, my lord, possible.
Possibly.
It's a brief code. I have to search out the brief.
So you
Next week, my lord.
hand over a copy of everything so that we can
appeal on behalf of the.
Anyway,
my lord,
just please, we are not directing anything.
No,
you do it amongst yourself.
I am.
Yes. A jointly played list after.
Find out whether the
In the meantime, take down. In the meantime, the department should give a report whether costs rupees 50,000 in terms of an earlier
24.
Item number 11.
11, my lord. Mr. Samanto is there. Mr. Samanto is for the petitioner. Actually, he was here. One matter has been called. That is why he has come. Prayer is, my lord. Kindly so pass it over for a short while. He will be coming.
Just let us go through the order. Let's see what is the issue.
Well, your lordship may remember that matter, yes.
Lordship was pleased to direct mediation as
Huh?
it was pleased to direct for mediation. Mediation as
Mediation failed.
Well, yes.
Had to.
Your lordship kindly sit on next Monday, my lord.
next Monday.
Huh?
Next month I have something. Other than next Monday.
তুমি বলো।
Let us take it up today. You are the
I am the the private respondent married daughter.
your wife, daughter. Who are you?
I am the respondent number 5 married daughter.
Married daughter.
Yes. Mr. Samanto is mother.
He is the for the mother.
Mother, yes.
You are the married daughter.
Yes.
And you?
I'm the unmarried daughter.
Unmarried daughter. So two of you are on one side and one is on the other, or all three are fighting.
Not all three are basically fighting. The mother is supporting the respondent number 5.
So therefore we said two are together. You
Yes,
and
yes,
with the mother are together.
But the married daughter has not
And you
come
say
up.
without your consent they cannot get it.
Yes.
They are saying that without my consent they cannot get it. And if your lordships are pleased to hold it, it would also apply to them. Without my consent, they cannot get it.
So it has not been paid to anyone.
No, not been given to anybody.
What is the date of demise?
Date of demise is 25th December 2015.
15.
Yes.
From which post?
And actually, my father was a Group D upper division clerk.
UDC. UDC. So it's a claim for family pension.
29th of December to 2015.
29.
Yes.
He said 25th.
No, 29. That is what the
No, father died.
Claim for compassionate.
Father died on 25th December 2015.
Saying 25th December. From where you?
Did it was 29.
The death certificate is there on record.
Just one minute.
They are claiming pensionary benefits or compassionate?
No, compassionate.
The daughter, unmarried daughter was claiming, and we had asked them to get the no objection. That is where the trouble starts.
So he claimed.
No, actually, my lord, I am giving my short fact of this case, my lord. It will be better for appreciating this.
No, first give us the fixed date. The date is still not fixed.
My lord, 25th December 2025, while here.
No, the learned AGP says 29.
29. The affidavit, lordship, at page 76.
Death certificate to
Lordship, page 76, the affidavit filed by the petitioner.
Page 76.
Yes, lordship. My husband.
Oh, sorry, my lord. Actually, it will be 29. 29, yes.
So now there is no dispute. 29/12/2015.
15, yes.
Yes, he's here.
We are both sailing in the same.
That's why we said that you are here, then you may take over. He was seeking a short passover. We asked him to give the relevant facts. So now you are here, you may take over. So 29/12/15, the employee died. You are the wife along with the married daughter claiming a benefit of compassionate appointment in favor of the married daughter. The authorities have not processed.
No, well, actually, I am giving the short fact, it will be better. No, he is running, that is why.
Yes.
Actually,
He's not
immediately
running, he's
after.
standing. He was running. Yes.
Immediately after.
Yes.
My lord, the death of my father, my lord. application was made for compassionate appointment
By you,
by the mother,
in your favor.
in my favor. That was not considered. That is why my learned friend client make an application before the learned tribunal. Learned tribunal directed for consideration. Now the consideration was made. During the the course of consideration, screening committee was constituted.
No, just a minute. Your application is dated? Your mother's application?
First mother application was 6 January 2016. That is in favor of the unmarried daughter.
Respond number?
6 January 2016.
In favor of respond number?
Unmarried daughter. The unmarried daughter, that is the respond number 1 here.
Respond number 1. So
Yes.
the mother made an application.
Subsequently, my lord, as the the unmarried daughter is living, left us more than 15 years and she is living with the stepmother. Now, immediately, my lord, my mother make an application for compassionate appointment.
In your favor. When is that?
That is, my lord, on my lord, it was submitted on, well, I'm just giving my lord. He submitted on page 76. Just, my lord, on my lord, he affirmed an affidavit on 23rd October 2017, page 76.
In favor of respond number?
Respond number 5 here, that is in my favor.
Married daughter.
Married daughter, yes. My lord, as my lord, it was not considered. My lord, married daughter, unmarried daughter make an application before the learned tribunal. Learned tribunal passed an order for consideration. Now, in pursuance of that, the screening committee was constituted. The screening committee, my lord, they recommended negative. Against that, my lord, both of us approached before this learned tribunal.
Why you are agreed by that?
Because, my lord, the screening committee was of the view that as my client claim, they claim, that is why they are in a fix not to determine. That is why
Where is the screening committee's recommendation?
Screening committee was 22nd February 2019.
21 September?
Yes.
22?
Yes, 22.
Yes.
22nd February 2019. Page 50.
50. It's 50, sorry, sir.
Now I'm giving the my lord a short fact, then it will be better, my lord. Thereafter, my lord, I will show you lordship, my lord, one by one. Page 50, your lordship, kindly come.
Where is it? Page 58 থেকে যে
Page 50, 50.
হচ্ছে এটাই হচ্ছে আসল রেজাল্ট এটাই আসল রেজাল্ট
Paragraph 5.
Have you lordship got it, my lord?
R1 is Ruby or R1 is Momi?
Respondent number 1 is
Momi. Here, Momi is unmarried daughter. Ruby Rani is the married daughter.
Momi is unmarried.
Unmarried, yes. Now, my lord.
So this was again challenged.
We challenge this order. Both of us. Now, my lord, it starts from page 51, ended 54, wherein my the learned tribunal, my lord, quashed this order, directed the principal secretary to hear out the matter.
You know, 58.
54, the last paragraph.
Last paragraph.
Then another order was passed.
Thereafter, my lord, the principal secretary, my lord, heard this matter.
Yes.
And order was passed. Page, it starts from page 58. And the ordering portion. That the principal secretary, my lord, recorded all these things, my lord.
Page?
Page, it starts from page 58.
58.
Page 58.
And the relevant
Ended
portion is at page 62.
62. My lord, before the authority, my lord, we also produced the judgment of the special bench that the married daughter is, my lord, is entitled to get it. Now the principal secretary.
So this was passed in favor of R1.
Yes, R1, subject to. Now your lordship kindly come relevant party 62, page 62.
Yes.
My lord, may I read, my lord? 62, that is the relevant part. Achha.
This is governed by 251 MP.
Yes, I have annexed it.
So that's got a compilation. And
Yes, we have.
in that compilation, it's not this.
But I have annexed, my lord.
Compilation to nature. To page tab.
Page. 251 is that December 13 one.
Yes, 13.
3rd December 2013.
My lord, your lordship kindly, Justice Roy, my lord, your lordship kindly take page 111.
No, we have got compilation. Don't worry.
Yes, that is why. This is the, my lord, the your lordship dealt with so many matters that this notification issued for compensate appointment. Now, have you got it, my lord? Page 1111. সব দেখাবো সব দেখে সব দেখাবো।
On the date of death, you were unmarried.
No, at that point I am married. Actually, what happened is this, my lord. Actually, the Mummy does marry unmarried daughter. He has left more than 20
No.
years.
Let us get the facts.
Yes.
We will
At
hear
that-
what you
yes,
are
yes,
saying.
At that time, yes.
So at that time, there is no dispute that you were at
Yes.
married
Yes,
daughter.
yes, no problem.
So, but you say that you were dependent.
Yeah, dependent. Yes.
What have you produced in support of your dependency?
But my lord, actually, my father, my lord, left my mother. That is why, my lord, I was there from the very inception. My lord, I am looking after my mother from the very inception. And my father left us, and he is living with my lord, the second wife. Now,
Father কিছু কিছু
আছে তো।
second. After that, finish is not by chance, it's not a fortuitous. When reading reveals the introduction, the sun was Moses gave the step on the one. So it indicates a prioritization also. Second thing is some yes, that ওইগুলো তো কোনো ফিল্টার নয় কি তার সঙ্গে সেটা না মায়ের তো বয়স হয়ে গেছে মায়ের তো বয়স হয়ে গেছে হ্যাঁ তাহলে we can claim married daughter তো এটাকে তো চ্যালেঞ্জ করি জাজ করি she has given to her right মজা ওরা কোনটা চ্যালেঞ্জ করছে হ্যাঁ it's a condition which has been imposed আমরা তো চাইবো
Now, my lord, your lordship kindly. Yes.
Is the format for
Yes.
which requires containing
Yes.
obtaining no objection?
Yes. Your lordship kindly come page 120.
page number
120. Scheme, my lord, your lordship kindly annexure part 1. Annexure part 1.
she's not able to show that she was yet.
One enterprise insurance.
এইখানটা দেখুন
Is not suggested. Yes.
Yes. Now, your lordship kindly come page 120. My lord, the 4. Signature LTI of the other dependent of the family member, giving no objection in favor of the application for employment on compassionate ground. That is one of the only condition. Before that, your lordship kindly come. My lord, the paragraph 10, page 115.
115.
My petition, petition.
115.
procedure for submitting application. Ten B. Application is to be submitted in the prescribed pro forma as Annexure A and B is applicable through the head office. In case of death of harness of such family must accompany.
There is no dispute that it does not have to be submitted on pro forma.
That is,
Nobody is
this is the procedure.
Point is whether and no objection from you is included in the pro forma or not. That is the only thing.
No, that is not there.
Because
Mother
they
has
have
not-
directed in your favor. Yes. But they say that you have to get a no objection from him. From the
Mother.
The pro forma supports such a requirement or it does not support such a requirement.
Now, my lord, they have approached before.
Where is your application made before the authorities? Any application or representation
Oh, yes,
which you
yes, that is
submitted, can you please show us?
Yes, yes. Well, just one. Just one. আচ্ছা আচ্ছা চল না না এখানে আছে
Please see page 46.
My lord, your Lordship kindly come. Page, my lord, 80.
What is at 46?
Others application. It's others. Others application.
My lord, this is earlier application
By the mother.
by mother.
In
Now
2016.
16. Now your Lordship kindly come page
6/1 2016. By
and thereafter your Lordship kindly come.
Please, just give us a minute. You are not kind to me.
Yes, sir.
You are not kind to me.
You are not kind to me.
Oh, yes, sir. I'm sorry. I'm sorry. I'm sorry. Kindly pardon me.
You have given a Bengali document.
Oh,
I don't know your great language. What can I do?
oh, yes, I have understood. Bengali.
ছোট মেয়ে মমতাজ চেম্বারকে হ্যাঁ শিরোবস্তাবার বাড়িতে বলতে হ্যাঁ এবার
প্রথমে দিস
Yes, where is your application, sir?
Yes, sir. Well, page 76 is the affidavit affirmed by my mother. That is in English. My serial number 5. That if my daughter Rubirani gets
76.
(76) of the writ petition.
My lord,
76. Yes.
affidavit
Affirmed by the mother.
Volume 1.
in 2017.
76.
এটাই ব্যাপারটা
দুজনে আমারটাও বলেছে ওটাও বলেছে একজন শুরুতে আমাকেও বলেছে
Maybe not page 76. 78.
No, that is Bengali.
Affidavit is in 76
Six.
and the application is in page 78.
Enclosing.
That's
Enclosing.
page 76, I find one
Affidavit.
prescription of a medical officer.
No, 70.
From 77, there is an application to the additional district inspector of schools.
Then that page 76 will be the relevant. Bottom date is 30/10/2017.
Now he knows. Today he knows.
No, that is not.
There is no affidavit in my brief. I can't find it. It is there in the second brief.
The application.
Application we have. It is
yeah.
an application dated 14/11/18.
Yes.
No,
No,
application.
Application is Bengali.
30th.
October 27.
Something is terribly wrong.
नहीं
80 is death certificate. October 23rd. In my brief, your affidavit is at page 81. It is of 2310.
Yes. 2310. My lord.
Page 81 in my brief.
I'm sorry. 2310. देखो तो तुम्हारे पापा 3010.
Then my lord, the next page is the application which was made thereafter, with enclosing this affidavit.
Yes, 78.
The top is addressed in English, my lord. Additional District Inspector of Schools and compassionate ground, etc. And then, my lord, bottom, the date is 30/10/2017. But
application.
Yes.
Application.
Where is the application?
Just after the affidavit page, my lord. Lordship has got the affidavit.
It is not, sir. After the affidavit in my brief, you have copy of the affidavit in opposition of respondent number 5.
হ্যাঁ মোটাই ঠিক আছে হ্যাঁ ওই তো ওই তো
This is the application.
ওই তো তাহলে
It is there in the second brief, my lord.
Yes.
actually it is our mistake বুঝলো যে তাহলে আমি ঠিক করে দেবো হুম
Lord, I tender apologies, my lord. Lordship will do this, my lord. Instead of.
Oh, it's so we have finally managed to see everything. We will proceed as it is.
এরপরে ইংলিশে আছে শান্তিরানী দাস নিজে অ্যাপ্লাই করেছে
Yes.
project teacher করে না এটাই মুশকিল এই ক্লাস
So dependent has been defined where in these 251 EMP
251 dependent.
3 clause 3 of the
yes page 101 page 1 spouse son unmarried daughter including legally adopted married daughter who on the date of incapacitation as unmarried and
My brother or sister.
and brother sister and this part has been my lord
That has to be read with this special bench.
special bench judgment
Yes, special bench says dependent.
Dependent. No, but it has clarified that part, saying that this is unconstitutional, not
Correct.
giving it to the.
So now it has been included in 3. 251 has included that. Unmarried and married, both daughters are now incorporated. This is probably after the special bench judgment.
No, special bench judgment 2017. Special bench, on the last occasion, I have handed over your lordship, my lord, the special bench judgment of Purnima Das.
Married daughter who was date of incapacity was unmarried.
তোমার ইয়েটা আমার yes.
Anyway, even if married, the issue of dependency was considered by the special bench.
No, there the issue was
Read where it says that every unmarried daughter.
here the issue was that the married daughter was totally excluded.
So therefore,
Now-
we are saying where married daughter who is not dependent, she is to be considered. Please show from the judgment that a married daughter who is not dependent is to be considered.
I'm just
the other
No,
aspect.
read from the affidavit, page 76, where you said that she is dependent.
Page 78, the application filed by the, my lord, the.
That's what we are saying. 2017 application for the first time, you said. That it did neither in 6/1/2016 nor in the affidavit in October 2017. For the first time, when you are making an application, after that, you say that he has abandoned. That does not make her dependent at the time of demise of her father.
But the admitted position is this, my lord.
That is the only admitted position.
Position, the, before, my lord, the married, my lord, I was fully dependent. Even after marriage, my lord, as my father left
That is
us,
admitted. From where they have admitted,
But-
please show. Where she has admitted to this. You are saying this is
Ac-
admitted
my lord,
position.
the actual fact is.
What is the meaning of admitted, sir?
Well,
You can't use admitted so casually and loosely.
Well,
Admitted means a fact which is not in dispute. It's not in dispute. Don't use expression admitted. You may say it is your submission. It's not admitted by anyone. It's not even admitted by your mother. Forget about R1.
My lord, in the affidavit, paragraph 3 of the
No,
affidavit.
page 87, a mother application. Well, your lordship kindly come page 87.
Paragraph
That
3.
application. Well, 14 November.
That my husband Chandi Charan Das died on so and so, leaving myself and my daughter Ravi Rani Giri, wife of Animesh Giri. Yes, that's a fact.
Your lordship kindly
There's
come
no
page,
issue of dependency.
well, your lordship kindly come page 87. The application of the mother. Your lordship kindly see.
Correct. 2017 for the first time.
No,
That's
no.
what we are saying.
No, mother's application is, my lord, your lordship kindly see 14 November 2018.
Correct.
Yes, 87. I'm reading.
That is
What
much
my
later.
mother said.
That we accept it. That does not improve your claim.
But my lord, I am reading, my lord.
You need not. We are accepting without reading. She has said you are dependent. She has said you have been abandoned. It does not lead to any conclusion that as on date of demise of your father, you are dependent. And that is a requirement under the special bench judgment as far as we recollect.
Your lordship kindly allow me to read, my lord, one paragraph.
For what, sir? If you are not required to convince us, why do you want to read? We are accepting it. Still you want to read.
No, what my mother said, my lord, by
No
when
issue,
the,
you are just trying to throw a spanner in the works. If she gets an employment, she will be bound to maintain the mother. If she does not, she will lose the job. As far as you are concerned, if you are not a dependent on the date of demise,
your lordship kindly just allow me to read one sentence, your lordship kindly. My lord, my mother, my lord, made an application on 14 November 2018.
your mother made 3 applications.
Yes,
Read all 3.
I am reading.
16/1/16 first. Read the 16/1/16 first.
Yes.
Then
Yes,
read the 17 one. Then read the 18 one. And see how the claim evolved. Please read.
well, I'm just, your lordship
Yes,
kindly.
read 16/1/16 application.
Yes, 16, my lord, admittedly, my lord, the 46, no?
46.
Yes, I have an extra. Yes. 14, my lord, he made an application in favor of the unmarried daughter. It is Bengali.
So that is over. Now come to the 17 application.
Now, 17 application is mine.
Six.
17 application, my lord, the affidavit.
Read. Where is it? Read 17 application.
Yes. It's কত বললাম যেন এটা?
76.
কত বললাম?
76.
Perhaps in your brief it's at page 76.
76 the affidavit.
What is the date of the 2017 application?
Application, my lord, affirmation on 23rd 10 2017. I made an application 23rd October 2017. This is affidavit, NOC.
Sir, we are not asking about affidavit. There is an
The affidavit in the form of NOC. That is yes.
We are asking you that there is an application also submitted in 2017.
Yes, yes. Next, my lord, page 78. 13, 10, 17.
10. That is the second application.
Second application.
And the third one is this 2018.
My lord, that
What
is
is the
my
date of 2018 one?
Yes, yes.
30-10.
2018.
No, sorry. No,
My lord, just
14th November 2018.
14 November 2018.
no, just. বার করলাম যে, oh yes.
So
My lord,
you read the 30th October 2017 application.
30th October 2017.
পেজটা কত? It is Bengali, my lord.
You read it.
করতে বলছেন তো।
আমি রুবিরানী গিরি সাজেন স্যার জানাইতেছি যে 29/12/2015 তারিখে চণ্ডীচরণ দাস পশ্চিমবঙ্গ সরকারের অতিরিক্ত জেলা পরিদর্শক অফিস চাকুরিতে থাকাকালীন অবস্থায় পরলোক গমন করেন। চণ্ডীচরণ দাস ও তার স্ত্রী শান্তিরানী দাসকে নমিনি করে যান। চণ্ডীচরণ দাসের একমাত্র কন্যা, প্রথম কন্যা রুবিরানী গিরি অর্থাৎ আমি বিবাহের পর থেকে চণ্ডীচরণ দাসের বাড়িতে বসবাস করে আসছি। দ্যাট ইজ সিন্স দি ডেট অফ ম্যারেজ মাই আই এম রিসাইডিং দেয়ার। চণ্ডীচরণ দাসের আয় থেকেই খাওয়া দাওয়ার ভরণ পোষণ যাবতীয় কাজকর্ম করতাম, কারণ আমার স্বামী আমার সঙ্গে ঘর সংসার করেন না। চণ্ডীচরণ দাসের দ্বিতীয় কন্যা ববিরানী দাস অন্যত্র বিবাহ হয়েছে, স্বামীর সঙ্গে ঘর সংসার করেছে। দ্যাট ইজ অ্যানাদার। চণ্ডীচরণ মারা যাওয়ার পর থেকেই শান্তিরানী দাস ও প্রথম কন্যা রুবিরানী দাস আমার কোনো প্রকার আয়ের উৎস নাই। দেনা করিয়া কোন রকম দিন আনা দিন খাওয়া অবস্থায় বাঁচে আছি। বর্তমানে সুস্থভাবে খেয়ে বেঁচে থাকার জন্য অবিলম্বে কম্পেনসেট অ্যাপয়েন্টমেন্ট আন্ডার ডাইন হেডস ক্যাটাগরিতে চাকরির প্রয়োজন। He made an application.
Correct.
Now, your lordship kindly.
Lord, there is one specific sentence here that after the demise of the husband, mother and Ruby Rani, the married daughter, they were living in penury, totally dependent upon the husband, the deceased husband, and did not have a condition to maintain themselves.
No, she says they were abandoned.
No, and the language is not. চণ্ডীচরণ দাস মারা যাওয়ার পর থেকে শান্তিরানী দাস তার প্রথম কন্যা অর্থাৎ আমার কোনো প্রকার আয়ের উৎস নাই।
After the affidavits, I have substantially affidavit.
পরিষ্কার নাই।
Not at the time.
Yes.
That is
So, my lord, there it's very clear in this 2017 application because he died in 2016, 2015. This is clear, my lord, that sentence is there that we are, he left us and we were dependent upon him, I mean, and we are in penury. That part is there.
If he left, how you were dependent on him?
Because
The
ultimately.
two are mutually destructive.
No, after
Cannot exist parallelly. You can't say that I was not taken care of and I was dependent.
Dependent in the sense, Lord, that ultimately the pension, etc., was coming to the mother.
Mother, there is no dispute.
Mother,
there is
along
no-
with the.
See, nobody can have a better claim than you.
No,
Nobody can have a better claim.
That's right.
But there is no doubt in our mind.
Maintaining the married daughter also.
We don't find it. maintain. We are being very clear that we don't find it.
there was no.
And my lord, the other aspect is, my lord, the tribunal said.
No, the application.
Tribunal, whatever it said, forget about it. That we understand. You have challenged.
Your lordship kindly see the mother's application. My lord, it is in, my lord, it is in English. Your
You
lordship,
will see nothing but 2016 application. That is the only contemporaneous application. You cannot evolve your claim every day. That's not permissible. If there was no application in 2016, things would have been different. 16, you clearly say, this is my unmarried daughter, other two are married off, they are living separately. So there's no question of at a subsequent date saying that they are dependent or they were dependent. She has never said that they were. She said that now they become dependent. After this application. So there is no claim made out.
Now your
What the tribunal has said, let us see.
Lordship will see the tribunal's order, my lord.
Yes. What has been directed by the tribunal? NOC from her mother is not an essential requirement. So you want to stand in the way.
Lord, there are reasons.
There may be. There may be. Then nobody will get.
That you tell from your lordship, we try, that's why we had gone in mediation.
Then there is no way out, then nobody will get. She cannot be considered to be having a better claim than her. We are very clear and we are being open about it. We have seen it. Now, if you don't want that she should get it under any circumstance, you can come in the way, she cannot. If you allow her to get it, she cannot escape your liability. Now, that's why we said you decide what you want to do. She is bound to take care of you the day she does not, her appointment will go. Because she is required to give an affidavit periodically that she is maintaining each year.
Already met.
And the moment it fails or you raise an issue, she will lose the job. Therefore, we said out of your proceeds, if you want to take care of her, whatever you want, you can do. Right now,
We tried it in the, so many days, mediation, ultimately.
upon
And the fourth.
Grateful lordships, much obliged.
Item number 2.
I appear for the petition.
Item numbers,
I am appearing on behalf of the Principal Accountant General.
রেকর্ড করেছিলেন না আগের দিনের ঘটনাটা সব?
এটা চেয়েছিল।
yes, Lordship, I have received instructions. But Lordship, I think I need to use an affidavit. If your Lordship kindly grant me, I'll incorporate all the documents on it. I'll incorporate all the documents on affidavit. Lordship. Because post, Lordship asked me what had happened after the issuance of the memo dated 4th of March 2021. The last order.
রেকর্ড করেছিল রেকর্ড করেছিল চাঁদনি
হ্যাঁ
রেকর্ড করেছিল
একটা রেকর্ড আমাকে আনতে বলেছিল রেকর্ডেড হয়েছে কিনা জানি না লর্ডশিপ আই হ্যাভ obtained instructions which I need to be use an affidavit incorporated a supplementary affidavit.
August.
31st August. You file it within 2 weeks, please,
Yes.
so that they can.
Yes.
Deeply. Appearance.
12 and 13 both.
9 and 12 and 30.
Both.
Same order.
Same order. You have to elaborate. Item number 13, 13, 14.
Lordship, in this matter,
In this matter, you,
Devashish Basu and Lordship just requested to pay for a small, short Passover.
Not today.
not. Item number 15.
Item number 15, I am appearing on behalf of the Principal Accountant General.
My lord, I beg to appear on behalf of the petition.
On what? See on here. बस से तुमको बोल रहे हैं तो रिमोट डालो
My lord, the issue is settled before you, by your lordship. My lord, in the case of Alochana Pan, Hiralal
Case of
Alochana Pan, Hiralal Ghosh and Geeta Nashkar.
which issue?
In Alochana Pan, my lord, state preferred SLP. SLP has been dismissed on the same issue.
Which issue?
Issue is, my lord,
Qualifying service after regularization.
yes, after regularization, minimum pension, my lord, is seeking.
Yes, now we remember.
My lord, these are the orders of the Supreme Court.
Last order is of 14 July.
But Lordship, I have not yet come. Lordship will kindly come to page 178.
178.
170. The tribunal has given this very thing work, not a continuous spell, maybe 2 months, maybe 13 days. Maybe. So that is how he had worked for a certain span of time.
Then why you regularized him?
It's an appointment.
Then why did you regularize him? Now is it open for you to say that? Your rule says if the continuous service has resulted in regularization, you must give.
A fresh appointment. That is.
He is given a fresh appointment. Please show us the appointment order. Please show us the appointment order.
service they completed will not get any benefit, but it will be cost so that it does not ensure so that challenge an issue that we will pay the minimum. Anyway, the Supreme Court has said that on this mooted issue, you could consider so that means entitlement is not something so I issue that if you take such a stand before the apex court, if the minimum pension for the remaining, we will keep it after the Supreme Court.
My lord, this is the order of the Honorable Supreme Court. Kindly.
Lordship Justice Vinod Chandan's judgment.
Ashtanuddin and Justice R. Mahadev.
No, this is where it was dismissed. But there is some case in which they have said we are confining it to an issue that will not pay more than the minimum.
We are seeking minimum pension.
Where is that one? Where is that order of this?
My lord, kindly see, my lord, in the case of Hiralal Ghosh, say, though this is pending.
Even after seeing that case of that petitioner also they are not being
Paragraph 7, my lord.
Still they are not.
Wait.
Further, my lord, may I read, my lord?
You have given a copy. We expect a standard of fairness to be the same before both the forums.
No, Lordship, this is something new which I thought.
Just leave it to read the last sentence of paragraph 5, where you have made a fair submission before the honorable.
Yes, Lordship, I thank you.
My lord, this is the order passed by in the case of Gita Noskar.
The transfer was decided by the.
Yes. Also, minimum there is a direction to give minimum pension.
They have not paid yet. We were informed by Mr. What is his name? Mr. Ishwaru.
Church.
ম্যাডাম এটা আলোচনা এটা ডিসমিস হয়েছে এসএল আলোচনা
Stated appeal.
Here at the outset, give this a-
Yes, ma'am. Gita Noskar.
at the outset, you made a submission before the apex. Now, the house has been taken. No, have you seen this? Gita Naskar order.
Gita Naskar.
Wait.
So therefore, we are saying you pay the minimum.
Minimum.
If anything else is to be done, we'll see after the Supreme Court disposes of the matter.
Lordship, the matters which are pending.
Yes, you maintain parity, you give the minimum pension, whether any more they will get or not. We'll keep the rate pending.
Lordship.
We'll give you time 15 days to take steps in terms of these orders, come back, and thereafter we'll keep.
Lordship.
We are telling you that the minimum is paid for the remaining will keep it pending. That is we are making it very clear in presence of the party.
Grateful, man.
The date.
31st. Item number 16.
My lord, I'm for the state led by learned GP, my lord.
Lordship will see the order passed on 15/12, my lord. Home Guards, for the post of Calcutta Police Constables. Your Lordship protected us.
Participated.
They participated. Results have not yet been declared, my lord. I think they chose in a subsequent submission they made that they will not file any affidavit. But ultimately, my lord, our purpose, by virtue of your Lordship's order, they are to publish the result and whatever happens, which will be subject to the result of the subject to the original OA before the.
Oh, OA is still pending.
My lord, we have filed reply there.
Then why we should keep it pending?
My lord can hear this matter.
But you have not filed any objection. How?
My lord, our original we have filed a reply in the OA, my lord.
That you have placed on record.
My lord, it is there on the record, my lord. They have filed it.
Yeah, really?
Page 98, my lord.
I think, my lord, because your Lordship will not adjudicate the OA.
We can, but point is, where is the urgency if they have already participated?
They have to let them declare the results.
My lord, we will, with greatest of respect, my lord, your Lordship had directed us to allow them to participate so that they are not prejudiced if they succeed in this application. That is why, and the examination will not be again held. That is why your Lordship directed us to allow. Now, this application has to be decided before I declare the result of those participants, my lord. Why I say this, my lord? Because, my lord, we have decided not to include them, my lord. This is our policy decision that this time we will not give them a reservation category there.
It's not reservation. They're claiming some
Age relaxation, my lord. So this is our policy decision that this time we are not giving an age relaxation to them. There is no
They are,
home guards, my lord.
and you have given a relaxation to?
To
that is very evident from your Lordship's order. I'm sorry.
Civil defense workers.
It is, my lord, recruitment of constable and lady constables, my lord.
No, you have given that relaxation to someone else.
Civil constables, my lord. Civil. No. I get my correction. Civic volunteers, my lord.
Civic volunteers.
My lord.
So how the civic volunteers are
Different
a class better than them? That is all. So tell us. What is the rationale for this classification? That's the only thing. Under which statute you appoint the civil volunteers? And under which statute you appoint the home guards?
My lord, may I be candid, my lord? In the earlier notifications, my lord, they were both the classes were allowed reservations, my lord.
Therefore, what you have taken a policy. Now you will not give it to them, but you continue to give to the other. They must be on a better platform than them. They have been given this relaxation and they have been excluded. So just justify it. That's all. There's nothing else.
With this regard to this particular query, my lord, I have sought clarification from the department itself, my lord. I'm yet to receive that because everything is clear from your lordship's last order, my lord.
Therefore, we say,
my lord, I'm yet to receive that particular
then
clarification.
come back with that.
Because tribunal, nothing has happened.
Now it is what, 10, 11 months?
More than that.
September 25. Oh, almost 1 year.
1 year. And we are moving the learned single bench.
What are you doing?
My lord, in the earlier government interview was taken, my lord, but we are yet to know that.
In Odisha, they have done away with SAT. West Bengal tribunal.
In my parents' state also.
Item 17.
Lord, item 17, my lords, I beg to appear for the petitioner. My lord, this matter has become infructuous because the advertisement by dint of which the petitioner has sought my lord to participate in the promotional process, that has been done away with, fresh advertisement issued, that has been challenged my lord in a fresh writ petition before the honorable single judge. And now, my lord, this is the order.
ওখানে তো ইয়ে ছিল না, ID card কি?
Item number 18.
Well, 18 I appear. But may I file one supplementary affidavit? Because well, it's a change brief. When the writ petition was filed, but the original OA application has not been annexed to the petition.
What is the date of filing?
Well, it was long back. It was in 2025.
The impugned order is there.
Not 25, 24.
24.
The impugned order.
The impugned order is 7th of.
Oh, this is
August.
disposed of by the tribunal.
It is disposed.
Yes, yes. The 7th of August 2025, the order was passed.
You are claiming disability benefits?
No,
Transfer.
transfer. Oh, but your lordship kindly have a look to the original application. এটাকে জোসেফ দিয়ে দিন।
You sought a direction from the tribunal to transfer you.
But I question the propriety or the inaction on the part of the respondents for not transferring me to a college.
And no consequential direction was sought.
Nothing. Well, the original application was dismissed. Your lordship kindly have a look to the supplementary affidavit once, then I'll go to the judgment.
No, you sought a direction. Don't say no.
Let
to page 40.
Your lordship kindly.
Come to page 40.
Page
40.
40 of the supplementary.
Yes, prayer L.
Sitting asleep.
No. What people? The page. It's up there.
Title, huh?
Page
Page
15. No, I can put in.
Prayer L.
Hmm.
না পরে হবে
That's all.
Entry model.
Entry model.
38. 38.
You sought a direction. Don't say you didn't seek a direction.
I kindly have a look to the prayer bullet, page 42 of the supplementary.
Have a look at prayer B, page 41.
40. The
Yes,
pages are not
page-
telling my lord is looking at.
That then you are responsible for that.
No. My lord is looking at. Today I have had it
Page 41
of the supplementary.
page 30 of the OA.
OA.
Page 30 of the OA, page 41 of your supplementary prayer 7B.
7B. Yes. Now. Exactly, but that's why, I said that I sought for a
No,
transfer.
we asked you, did you sought a direction? You said, no, we have challenged. We have not sought a direction.
What I'm on is,
No, we are not on what you, we asked you a question of fact. So you did seek a direction for your transfer from the tribunal. That a tribunal should direct for your transfer.
yes. At present, the question is that whether the writ petition in which the tribunal has passed the order, I was an associate professor, I was appointed by the College Service Commission. The first appointment, thereafter the first, second posting.
No, you are claiming at, what is this order? Come to 16/8/22 order.
No. Impugned order. Impugned order.
Page 120.
120.
127.
Present order, which I have questioned.
It should be 127. That is the certified copy starts from there.
No. The
impugned order is
supplementary.
7th of August 2025.
16th August 22. Page
Present
120.
order.
That is the order impugned before the
Yes,
tribunal.
yes.
Absolutely.
Page 127 of the supplementary affidavit.
Supplementary. कोई कह रहा है कौन सा?
16.
Yes. My case is that according to transfer guideline, which in the recent order at page 127, the case has been rejected. Your Lordship kindly have a look to my first page 72. In 2019, the transfer list was published.
Where is clause 10? Where is clause 10?
Yes, clause 10. My Lord kindly comes to the transfer guideline, page 69. Supplementary. Page 70 is clause 10. After completion of 3 years for D zone and 4 years for A, B, and C zone, an incumbent may express in writing his or her choice of posting in the remaining zone in order of preference through principal so-and-so of the concerned college.
So how it is impossible? You may submit. Where does it say it has to be granted?
No, page 71. In the application, it was forwarded through the Director of Public Instruction. I said that for the look after the education of my son and daughter and my medical ground.
We are not on the reason for your claim. We are on where a right is created in you to seek that a direction should be issued for enforcing this.
Yes.
If the enforceable right on which clause gives you enforceable right?
But
Once you have made a representation, it must be granted. Yes.
Very well. Your Lordship kindly have a look page 97. Before that, the order of the tribunal.
Clause
Page
10 does not give any right whatsoever.
No.
It only says you make an application. You may make an application.
The tribunal has given the power to me, page 119. Can you have a look? I approached the tribunal earlier in an earlier round of litigation on 25th of January 2022, page 119. The tribunal said page 120, last paragraph, since the applicant has joined the transfer port at Shingur and paid for by Mr. Swanso, the application is disposed of by granting liberty to the applicant to file a representation ventilating his grievance before the Director of Public Instruction. Exactly on this point, I made a detailed representation, which is at page 122.
We are asking you, the question will remain the same.
Yes.
Then enforceable through a direction, that is the only thing you have to show us. We are not asking you fact that I made an application, tribunal said to decide. How you get an enforceable right that a court will issue a direction that you shows this man here?
Because I in the present order also and in my application page 123, I have made few points which I narrated before the Director of Public Instruction, on which ground I may be transferred to a certain college where there is a clear vacancy, and I will show to your Lordship
there is a vacancy. What other ground?
There is a clear vacancy, but in spite of
the moment you ask, you have to be sent.
No, that is not the case.
So
but the case,
how you are claiming an enforceable right?
This is not an enforceable right. But
how you can seek a direction from the tribe?
But I sought for a direction before the tribunal. The tribunal said you make an application.
We are running in circles, sir. Now we are running in circles. You have showed us the tribunal said he will make a representation. It was considered. Does that create an enforceable? Which gives you an enforceable right? That I must be posted at this place because I want to do.
Because of the.
If they are not doing it, you give a direction.
Because of the policy, clause 10. And as I have I had been in on track.
You have completed all those 10 years.
Yes.
Whether it is enforceable right.
If I can demonstrate before this court that there is a clear
where my lord I not suffice. You have to show that any rule, regulation or statute gives you a right. We don't go into this, but we accepted that there is vacancy. We accepted that we have considered, we have completed that tenure. Still, can you claim a right that the court should direct that you be posted there?
Well, on two grounds, well, I made that representation. Well, first is well, on medical ground, which I have annexed,
Into that.
and second is for the education of my children.
You are not going into looking into that unless you make out a right. There is a question of looking into the sufficiency of the reason.
Well, then your lordship can have a look to the transfer policy once for my satisfaction. Very good.
What is the law? Show us the law on transfer.
Yes. But your lordship can have a look to the transfer guideline number page 69. It said, clause 10, after completion of 3 years for so and so, an incumbent may express in writing his or her choice of posting. So this gives me a right to express my mind before the appointing authority to express my mind that see there is a vacancy where I may be posted. Just now my lord has said that if I have completed all the formalities and I have completed all the postings, so what is my right? Clause 10 gives me that handle to approach the department, mentioning before the department as look, there is a vacancy. If your lordship kindly have a look to the vacancy.
No, we are accepting it. Don't labor on that. We are accepting there is a vacancy.
And
we did not show that.
And your lordship kindly have a look to page 79 once. The person, the moment I was transferred to one of the college at Shingur on 3rd of December, page 76. Page 76, can I have a look? I was transferred on 3rd of December. On the very next day, the vacancy which I sought for, or the college in which there is a vacancy, had been filled up. But first of all, the clause 10 gives me that handle. Yes. Secondly,
you have said clause 10, you have said existence of vacancy.
Yes, and therefore, the moment I went to the tribunal on the strength of clause 10 had directed me to make a detailed representation. I made it. Now, clause 10 says that whenever there is a vacancy, you may apprise the department. I have apprised, and there is a vacancy. But in spite of that, on 3rd, I was transferred to a college, and on 4th, on the very next day, that vacancy which I sought for had been filled up by such a candidate which doesn't have the exact qualification. Kindly have a look, page 79. Supplement. The college in which that professor had been posted is clearly mentioning to a letter by to me addressing that they sought for a professor in the Department of Teaching Staff of Chemistry. Now, the professor who had been sent for that specific college is from inorganic subject specialization. And page 80.
Respondent number?
Which one?
His respondent number?
The college?
No, the person you are alleging has been wrongly posted. He is what respondent number?
Just a second. Give me 1 second.
But he has not been made a respondent.
Now, any other point?
But it's a change brief.
Sir, it is tribunal battle is over.
Yes, yes, true.
Other point.
Now, kindly have a look to page 80. All the colleges I have made party.
Maybe we have a scope for the tribunal to issue such a direction. It's not there even to interfere with your transfer, let alone issuing a direction that this person be transferred at such. Convenience is inconvenience. Every employee may raise an inconvenience.
True.
The administration will get crippled if they start looking into such inconvenience.
But if the transfer policy give me that handle.
So then how many times? You already said that. Whether 10 gives you a handle or it does not, then we are going to consider right now.
Very well. Then, your Lordship, kindly have a look to page 80. My Lord has seen page 70, 79.
You want to show these facts.
But these facts are important.
Everything will hinge only on one issue. Whether any provision gives you an enforceable right to oppose a transfer, let alone seek a transfer.
But I am not against the transfer. The case is that
Therefore, again we are saying, any statutory provision rule gives you an opportunity to oppose a transfer, let alone seek a transfer.
But I am not on that.
We are on that.
But I could not make myself clear to your Lordship.
Once that comes to the fore, we can go into whether the conditions exist for enforcing that right or not.
If the
cart cannot be put before the horse.
True.
So therefore, unless you show that there is an enforceable claim, there is no scope for looking into whether there is a vacancy, whether somebody incompetent has been sent. These issues don't arise.
But I demonstrated before your Lordship that
Clause 10.
Clause 10. And on the strength of clause 10, I made the representation.
Tribunal said that you consider.
Yes, but tribunal said to make a detailed representation. On the strength of the order of the tribunal, I went to the department. The department said no. I questioned the decision of the department before the tribunal. The tribunal kindly have a look to the order of the tribunal once. But 7th of August 2025. What the tribunal has said. In terms of such direction, the respondent authorities, the director of so passed a reasoned order contained in memo number so. The reasoned order elaborately recorded the transfer policy and posting history of this applicant and came to the conclusion that his prayer for transfer to government colleges showing so, namely so or so college, are not acceptable. Then the tribunal had again heard the applicant's case and properly examined all the records, including his representation before the authorities. After such examination, the tribunal is not satisfied with the ground praying for such transfer. Then, in his representation, he has mentioned that he suffers from so and the disease cannot be accepted as a serious medical situation. It is clear to this tribunal that this application is bent on persisting with his mission for a transfer near home, Purva Medinipur. It is not to be forgotten that the Honorable Supreme Court in so when the court, the judgment has been quoted, thus the application disposed of without passing any order. So, the tribunal has not dealt with the issue of the clause 10. This is my case.
Why we are dealing.
I'm so grateful. I may be wrong in making some submission, but what is my case? I have presented before your Lordship. I may not have a right, but the right has been crystallized because of the order of the tribunal.
my first appearance before Justice Rai. Great.
Item number 19. Item 19. Item 19, my lord. Or your lordship kind of look at the. No, this is the reply, my lord. It's been exchanged. Your lordship can have a look at the order dated 13th of January 2026. Lord, everything is brought on record by that order, my lord. Item on reply. Now the matter is not evolving in a small campus of Malad, whether the suspension order can be reviewed or not. Malad, from 2019, I mean, President of suspension, no review, nothing. And in the opposition, Malad, they have stated, well, it's still under review. Malad, it's an accepted position, it's still reviewed, had not been reviewed for once. Malad, I think I have also, Malad, if your lordship takes some reply, I have annexed the, Malad, the government order.
Fair idea what the case is. What do you stand? Just show from the opposition.
From a option, document comes at page 13.
Page number data Aryan Department.
Yes.
At page 12, I have narrated the entire incident. The fact was that there was a suppression of material facts, madam. When he was absent from
Yes. Yes. So what is the page 12?
Page 13, my lord.
Yes. What are you saying?
The focus which was submitted by the petitioner, my lord, at point of time when he was asked for why he was absent from duty. He came up with a reply that I was constrained to inform you that was due to some unavoidable circumstances I could not attend. But the fact remains that he was charged with criminal under section 1336 IPC at that point of time at the law was hanging, my lord. And he did not disclose this fact before the authority.
How that is relevant to continuance of his suspension?
That was
how that is relevant to continuance of his suspension. You tell us.
That was the only reason, my lord. He was suspended.
Suspension. We are asking you your stand with reference to suspension. You are placing something totally irrelevant, which has nothing to do with an issue of suspension. He may be the biggest crook in the world. We are not on that. There is a procedure which circumscribes your decision. Nobody has an absolute discretion. So how you have complied? That is the only issue.
That you have that coming to paragraph 12 of this my opposition, my lord. In the lower end, I have mentioned that suspension of
anything unauthorized absence and family affairs. How that is relevant?
Suspension is still continuing, madam.
You have said nothing, then we'll record that you have said nothing about the continuance.
Not only they have stated paragraph 17, page 7 is under active consideration. Last line, my lord, your lordship will find. They have quoted the memo and my lord said this.
It's called active, then we don't know what passive is. June 11, 2012.
Yes, my lord. That is, my lord, I have annexed in my my lord reply. My lord, you logically have a look at
One judgment we have considered.
yes, my lord, and that is, my lord, WPSP 91. My lord, dear my lord, initially review was found, but they did pass an order without giving any reasons why it should continue. There your lordship interfered, my lord. And in this case, review has not been done. Your lordship, kindly take a look at one of the reply that I have filed. My lord, the memo has been annexed. The rule has been quoted in terms of the rule. My lord, this memo was issued.
Where is that?
My lord, page 16 of my reply. Only one annexure is there, my lord. Yes, my lord. That circular has been annexed, my lord.
Yes, this we have considered in that.
Absolutely. Ramesh Hajra. In the matter of Ramesh Hajra, my lord. In the matter of Ramesh Hajra, the petitioner's name. দেখো সার্থক করে দেখো রমেশ 2025 রমেশ চন্দ্র হাজরা।
You are on which post?
Well, I'm my lord, a dentist. My lord,
Which page is the suspension order?
my lord, suspension is at page 46. This is dated 15th of July 2019.
15 July or June?
15th July 2019.
Suspension order?
Suspension order.
After that, nothing.
Nothing. But I made representation after representation, my lord. Nothing, my lord.
And you have submitted your written statement of defense.
No, my lord, even that proceeding started, my lord, thereafter nothing. And my lord, the criminal cases which has been said to be there, my lord, but although in their affidavit they have said, learned code, in the affidavit they said, my lord, police in collusion has submitted a report which was not accepted by the court. The order says contrary. The order says, my lord, Naraji petition was filed and that was rejected.
No, that's not, we are not concerned.
I'm not on that.
That's not
I'm
the
not on
issue.
that, my lord. পেয়েছো কমিশন হতে পেয়েছো ঠিক আছে এবার তুমি ডকুমেন্টস 99 এখানে পেয়ে যাবে
You are appointing authority is the governor.
Yes, ma'am. Governor is appointing authority. Procedure.
We'll pass the order tomorrow. My lord,